the numbers would be far lower than they are. Now, one question then is, what about race? Right, because if you look at the numbers closely, you'll see that African Americans and Hispanics and persons of low income in general are overrepresented on death row. In other words, they are more likely to be executed or given the death penalty than whites are. There's a lot to think about there. There's a lot to explore there. We don't have time, unfortunately. But the Supreme Court has chimed in on this. Because, of course, some folks wonder if this is the result of racial discrimination. And if so, it must be a violation of the Equal Protection Clause, right? But the Supreme Court has said, not so fast. They said, look, we acknowledge that there are some situations where someone may have been sentenced to death on the basis of their race or ethnicity. Certainly there's potential for racism in the criminal justice system, said the court. But they didn't buy, the Supreme Court didn't, the argument that the fact that African Americans and Hispanics are overrepresented on death row means that the whole criminal justice system is built on a foundation of racial discrimination. They said you can't. We're not convinced that there's enough evidence to prove that. So the Supreme Court has said that that it is possible to prove racial discrimination led to the death sentence, but only on a case-by-case basis. And you have to prove, as a person who's been convicted of murder, say, and sentenced to death, you have to prove that the prosecutors and the police, in your case, acted on racial malice. And you had to prove that with evidence somehow, obviously making it almost impossible to do, right? So the Supreme Court has pretty much rejected the argument that the fact that minorities are overrepresented on death row constitutes a violation of the Equal Protection Clause. That's I'm going to throw out too, unless you prove otherwise on a case-by-case basis. And then finally, the Supreme Court has said that there are a number of limitations with respect to the death penalty. A number of ways that the death penalty might violate the Eighth Amendment's ban on cruel and unusual punishment. Remember, the death penalty alone does not violate the ban on cruel and unusual punishment, but using it in some ways is a violation of the Eighth Amendment. For example, the Supreme Court has pretty much said that you can never apply the death penalty in a case involving anything other than murder. At the federal level, you can be executed for treason, and the Supreme Court has said that's fine. But at the state level, generally, it's murder, and really nothing else. So, for example, they said that rape of an adult woman, if the victim is not killed, is not going to be, the application of the death penalty in that kind of case would be a violation of the Eighth Amendment ban on cruel and unusual punishment. They said that persons who are insane should not be executed, because that would be a ban on that would be a violation of the Eighth Amendment's ban on cruel and unusual punishment. They're not responsible for their actions, and they shouldn't be held responsible in that way. Persons who are, quote-unquote, mentally retarded is the phrase that was used back then. Persons with very low levels of intelligence, low IQ, who are barely functioning as members of society, cannot be executed, as far as the Supreme Court is concerned. And then finally, persons who committed crimes while they were minors, we've already seen this in the last couple of weeks, cannot be executed either by a state. These are just some of the limitations imposed by the Supreme Court. While maintaining, right, that the death penalty generally is not a violation of the